The courtroom went silent, and then the judge spoke. No one expected it. Cameras weren't allowed inside, but word spread fast. During a heated hearing, former Florida Attorney General Pam Bondi made a comment about activist judges, and within seconds, the presiding judge rebuked her in open court. What happened next wasn't shouting. It wasn't chaos. It was something far more powerful, a reminder of how fragile courtroom decorum can be when politics and law collide. Tonight, we break down exactly what happened, why the judge stepped in, and what it means for courtroom advocacy going forward. The case had already drawn national attention. Supporters packed the gallery early, filling every wooden bench before the clerk even called the room to order. Reporters lined the courthouse steps outside, speaking in hushed but urgent tones into waiting cameras. Legal analysts speculated on possible outcomes. Social media buzzed with predictions. Everyone sensed that something significant might unfold. Inside, the atmosphere was formal but tense. The courtroom itself felt heavy, not chaotic, not loud, but charged. The seal of the court loomed above the bench. The flag stood still in the corner. Every shuffle of paper echoed more sharply than usual. Even the quiet clearing of a throat seemed amplified. When Pam Bondi rose from her seat, the room instinctively stilled. Bondi is no stranger to high-profile litigation. As a former state attorney general, she has argued complex matters under intense scrutiny. She carries herself with confidence, and that morning was no different. Her posture was straight. Her tone deliberate. Her pace controlled. She began by addressing the court respectfully, outlining the procedural history of the case and the specific motion before the judge. At first, everything felt routine. She explained why she believed the prior ruling misapplied precedent. She cited case law. She referenced statutory interpretation. She spoke about constitutional boundaries and the limits of judicial authority. Her argument was structured, methodical, and clearly prepared. Then her tone shifted, subtly, but noticeably. Bondi broadened her point. She began discussing what she characterized as a larger trend in the judiciary. According to her framing, some courts, in recent years, had stepped beyond interpreting the law and had begun reshaping it. Her words remained calm. There was no shouting. No dramatic gestures. And then came the phrase. She referred to activist judges. It wasn't shouted. It wasn't emphasized with force. But it landed. In political circles, that phrase is common. It's used in campaign speeches, op-eds, televised debates. It's shorthand for a belief that judges are deciding cases based on personal ideology rather than strict legal interpretation. But in a courtroom, the phrase carries a different weight. Inside those walls, judges are not political actors. They are arbiters of law. The integrity of the institution depends on that distinction. Suggesting activism, even indirectly, can be interpreted as questioning impartiality itself. A subtle ripple moved through the gallery. Some observers exchanged quick glances. A reporter's pen paused mid-sentence. Even the opposing counsel shifted slightly in their seat. Up on the bench, the judge's expression tightened, just barely. It wasn't outrage. It wasn't visible anger. It was attentiveness sharpened. Because courtroom language matters. Every word is recorded. Every phrase becomes part of the official transcript. Legal arguments are expected to focus on reasoning, not rhetoric. And in that precise moment, the judge recognized that the tone of the discussion had edged toward something broader than the specific motion at hand. The courtroom remained silent. But everyone understood that something had changed. The interruption was swift. There was no hesitation. No whispered sidebar. No long pause to let the comment drift away. The judge leaned slightly forward, hands resting near the edge of the bench, and addressed Pam Bondi directly. The tone was controlled, but unmistakably corrective. The message was clear: this courtroom is not a political stage. It is not a campaign rally. It is not a television panel. It is a forum for legal argument grounded in precedent, statute, and constitutional structure, not commentary on broader judicial philosophy. The judge calmly stated that labeling members of the judiciary as activist ventures beyond critiquing a legal ruling and into questioning institutional integrity. Even if the comment was not directed at the court personally, the language itself carried implications. Inside a courtroom, words matter differently. According to those present, the judge reminded counsel that public confidence in the legal system depends heavily on the perception of neutrality. Courts do not command armies. They do not control budgets. Their authority rests largely on trust that decisions are based on law, not ideology. Characterizing judges with politically charged language, the court suggested, risks eroding that trust. The rebuke wasn't loud. There was no gavel strike. No raised voice echoing through the chamber. But it was firm. Every syllable was deliberate. Every phrase measured. The gallery sat frozen. Even the subtle hum of shifting papers seemed to stop. Reporters leaned forward slightly. Opposing counsel remained still, careful not to appear reactive. In that moment, the focus shifted. The hearing was no longer solely about the motion being argued. It became about professional responsibility, about the standards that govern courtroom conduct. Courtrooms operate on a structured hierarchy of respect. Lawyers advocate fiercely for their clients. Judges rule. Clerks record. Each role carries boundaries. Judges are expected to remain impartial, detached from political debates and external pressures. Attorneys, in turn, are expected to challenge rulings through legal reasoning, not rhetorical framing that implies bias. That distinction is subtle but critical. An attorney can argue that a court misapplied precedent. They can argue that a ruling conflicts with statutory text. They can argue that a decision should be overturned on appeal. But when rhetoric shifts toward labeling judges as part of a political movement, even indirectly, it treads close to questioning motives rather than reasoning. And courts guard that boundary carefully. The judge's intervention was not about silencing disagreement. It was about preserving decorum and ensuring that arguments remain anchored in law. When rhetoric crosses that line, even unintentionally, the court often steps in to recalibrate the tone. That is exactly what happened here. The interruption served as a reminder: the adversarial system thrives on strong advocacy, but it survives on institutional respect. For a brief moment, the courtroom wasn't debating statutory language or constitutional interpretation. It was reaffirming the rules that allow those debates to happen in the first place. And once the correction was made, all eyes turned back to Bondi, waiting to see how she would respond. Here's where it gets interesting. When the judge finished speaking, the room seemed to hold its breath. All eyes shifted back to Pam Bondi. This was a defining moment. Some attorneys, when corrected publicly, instinctively push back. Others become defensive. A few double down. But Bondi did neither. She didn't argue with the judge. She didn't attempt to relitigate the reprimand. And she certainly didn't escalate the tone. Instead, she did something strategic. She clarified her intent. Calmly, and without visible frustration, Bondi explained that her comment was not directed at the court personally. She stated that her concern was broader, what she described as a legal trend in certain rulings across jurisdictions. Her focus, she emphasized, was on doctrinal expansion, not individual motivation. That distinction matters. In the legal world, criticizing reasoning is not only acceptable, it's expected. The adversarial system depends on it. Attorneys routinely argue that a court misapplied precedent, misinterpreted statutory text, or extended constitutional principles beyond their proper boundaries. Entire appellate systems are built around the idea that lower courts can get it wrong. Appellate briefs often use strong language. They may describe decisions as flawed, inconsistent, or unsupported by the record. They may argue that a ruling represents an unwarranted departure from established doctrine. But there's a careful line. When criticism shifts from reasoning to characterization, especially politically charged characterization, it can blur the boundary between legal disagreement and implied accusation. The phrase, activist judge, carries implications beyond analytical critique. It suggests motive. It hints at ideology driving outcome. Even if unintended, it can be heard as questioning impartiality. Bondi appeared to recognize that line in real time. She pivoted quickly. Rather than continuing with broad commentary, she reframed her argument in precise constitutional terms. She spoke about separation of powers, the structural principle that limits each branch of government to its defined role. She argued that courts must interpret law, not create it. She cited precedent from higher courts emphasizing judicial restraint. Her tone remained composed. Her delivery steady. Instead of political language, she used legal vocabulary, textual interpretation, statutory construction, legislative intent. The shift was subtle but deliberate. Observers later noted that this pivot demonstrated experience. High-level litigators understand that persuasion depends not only on substance but on tone. Once the judge signaled discomfort with the phrasing, Bondi adjusted without surrendering the core of her argument. And that's an important nuance. She didn't retract her legal position. She refined its presentation. The hearing moved forward. The discussion returned to the specific motion before the court. Case citations replaced charged terminology. Procedural posture regained center stage. Yet the exchange lingered in everyone's mind. Because moments like that reveal more than legal strategy, they reveal courtroom instinct. They show how quickly an advocate can recalibrate under pressure. They highlight the delicate balance between passionate argument and institutional respect. For those watching, the lesson was clear: in court, precision isn't optional. It's essential. And sometimes, the most powerful move isn't pushing harder, it's adjusting smarter. So why did this brief exchange make headlines? Because it tapped into something much bigger than one comment in one courtroom on one day. It highlighted a growing tension in today's legal climate, a tension between law and politics that has become increasingly visible across the country. In recent years, debates about judicial philosophy have moved beyond law schools and appellate opinions and into everyday political conversation. Terms like activist judge, originalist, and strict constructionist are now common on cable news, podcasts, and campaign stages. They're used to signal broader ideological positions. They energize voters. They frame narratives. But inside a courtroom, the rules are different. Precision matters. In judicial proceedings, arguments are expected to be grounded in statutes, precedent, and constitutional text. The focus is on reasoning, not rhetoric. Judges are not political commentators, they are tasked with interpreting and applying the law as written. When a politically charged phrase enters that environment, even briefly, it can feel disruptive. Judges guard the integrity of the judicial branch carefully. Unlike the executive or legislative branches, courts rely almost entirely on public trust. They do not have the power of the purse or the sword. Their authority depends on confidence that rulings are rooted in legal analysis rather than personal ideology. If that perception erodes, so does institutional stability. That's why language matters so much. When an attorney uses a phrase like activist judge, it risks shifting the narrative. Instead of debating whether a precedent applies or whether a statute was properly interpreted, the discussion begins to orbit around motive and philosophy. It can sound less like a legal critique and more like an institutional accusation. Even if that wasn't the intent. And that distinction is critical. Attorneys absolutely have the right, and the duty, to challenge decisions. Strong advocacy demands it. Lawyers must argue when they believe a court has misapplied precedent, expanded a statute beyond its text, or interpreted constitutional provisions too broadly. Appellate systems exist precisely because courts can disagree with one another. But those challenges must be framed in legal terms. There's a difference between saying, this ruling conflicts with Supreme Court precedent, and saying, this is judicial activism. One focuses on analysis. The other suggests ideology. The judge's rebuke, therefore, wasn't about silencing disagreement. It wasn't about shielding the court from scrutiny. It was about reinforcing boundaries, about reminding everyone in the room that the courtroom is a space governed by legal discipline, not political shorthand. For legal observers, the moment served as a powerful reminder: courtroom advocacy is distinct from public commentary. The same phrase that might generate applause at a rally can trigger correction at the bench. And seasoned litigators understand that dynamic. They know when to press hard and when to recalibrate. They recognize that credibility with the court is as important as passion for a position. Once the line becomes visible, experienced attorneys adjust their tone without abandoning their argument. That's what made this exchange so compelling. It wasn't explosive. It wasn't theatrical. It was a glimpse into how the justice system maintains its balance, one carefully chosen word at a time. After the hearing concluded, the courtroom slowly emptied, but the conversation was just beginning. Outside the courthouse, reactions were divided. Supporters of Pam Bondi argued that she had voiced a concern many Americans share. To them, her reference to judicial overreach reflected a broader national debate about the proper limits of the courts. They saw her comment not as disrespectful, but as candid, a direct acknowledgement of tensions that already exist in public discourse. Others, however, viewed the moment differently. They believed the judge acted appropriately, even necessarily, to reinforce professional boundaries. In their view, the courtroom must remain insulated from the increasingly charged language of politics. Allowing phrases like activist judge to go unchecked, they argued, risks normalizing rhetoric that can erode confidence in judicial neutrality. Legal analysts largely took a measured tone. Most described the exchange as instructive rather than explosive. It wasn't a scandal. It wasn't a meltdown. It was a brief but meaningful correction, the kind that happens in high-level litigation when language strays close to sensitive territory. Importantly, no sanctions were issued. There were no contempt findings. No fines. No written reprimands. Just a public correction, and a course adjustment. In many ways, that's exactly how the system is designed to function. Attorneys push hard. That's their role. They test arguments. They challenge interpretations. They advocate zealously for their clients. Judges, in turn, ensure order. They maintain decorum. They draw lines when necessary to preserve the integrity of the proceedings. And then the law moves forward. What made this moment stand out wasn't chaos, it was calibration. But the exchange also raises a broader and more complex question. As political language becomes more common in legal debate, not just in public forums but sometimes creeping into court filings and oral arguments, will courts need to draw clearer lines? Will judges become more proactive in policing rhetoric that carries ideological undertones? Or will advocates continue to test the boundaries between forceful critique and institutional commentary? Courtrooms are among the last public spaces where structured discourse still dominates. There are formal rules of evidence. Rules of procedure. Rules of professional conduct. Even tone and phrasing are shaped by long-standing tradition. Every word matters. Every phrase becomes part of an official transcript. Every argument contributes to a permanent record that may be reviewed by appellate courts or scrutinized by the public. In that environment, language isn't just expressive, it's consequential. For viewers watching from the outside, this exchange offers something rare, a glimpse into the delicate balance that sustains the legal system. It shows how passionate advocacy must coexist with professional restraint. How disagreement must remain grounded in legal reasoning. How institutions protect themselves not through force, but through standards. It reminds us that the justice system isn't just about winning arguments. It's about preserving trust. It's about ensuring that even in moments of tension, the structure holds. And sometimes, it takes just a single phrase to test that balance, and a measured response to restore it. If you found this breakdown insightful and want more behind-the-scenes analysis of courtroom moments like this, make sure to like, share, and subscribe to the channel. Because in today's legal climate, understanding what happens inside the courtroom has never been more important.